As a preliminary remark, nevertheless, I would like to adhere to a German legal construction. To a German legal construction which is the importance and the value of human rights in our constitution. Why do I say this? Because in all what happened the last 5 years with regard to austerity measures, anti-crisis measures, etc., human rights were the blind spot in this whole construction. The blind spot in the whole construction, which is, in my view, somehow the very basis of our analysis, what went wrong. And I think the starting point if we want to change something on the institutional level with regard to the future. Why do I call it a blind spot, and why was I referring to the German system? I do this because German politicians in their practice are very aware of human rights, because the German fundamental law, the Grundgesetz, has a very strict human rights catalogue, and even more important, a very strict constitutional court in Karlsruhe, which is having a clear view on that and is protecting those human rights. So if there is a law violating it, and politicians sometimes have the tendency, because of the pressure of politics, to do this or that, Karlsruhe comes half a year later and says, no, that was not correct what you did, it is violating human rights, this law is now void. This created, after decades of case law, a Klassenpolitik that is very aware of this mechanism, and is by that anticipating human rights issues when drafting laws. And the very purpose of human rights is not supporting the majority, because the majority is already strong in the decision-making procedures in the parliament. They have the majority. It is always protecting the minority. So anticipating minority rights when drafting a law is a complete different perspective than when you are legislating without having to fear that there is a constitutional court which will cut off everything what you did because you are violating minority rights. Why do I say this? Because from a European legal perspective, and this is my task of today, from a European legal perspective, the whole situation is quite depressing. We have nothing like a constitutional court kind of mechanism when it comes to those institution measures, troika measures, ESM measures. There is no way that those who are making those decisions have to be afraid that the European court will come and say those activities are violating human rights, and by that they are void, just as German politicians have to fear it when the German Constitutional Court decides in such a way. But in order to explain this whole situation, let me first recall the legal construction of those austerity measures. The legal construction is basically currently enshrined in the ESM treaty, but it worked like that before when it was the EFSF. There must be first a request of a member state to ask for stability support at the ESM. Then the ESM Board of Governors shall entrust the European Commission in liaison with the ECB, whatever that means, in legal terms, to negotiate a so-called Memorandum of Understanding, which then includes all those measures that a country has to fulfill in order to receive financial assistance. A draft MOU has then to be approved by the ESM Board of Governors, and the ESM Board of Governors then entrusts the European Commission to sign on behalf of the ESM. Once the MOU is concluded, national laws have to implement all those measures that they were signing up for in the MOU. Now, why a Memorandum of Understanding? Why not a good old agreement between one international organization on the one hand, the ESM, and a sovereign state on the other hand, Greece, Portugal, Ireland, Spain? The very purpose of an MOU is that it is non-legally binding. It is a non-legally binding declaration of intention to act. The parties of an MOU say, I intend to do this. If I don't do this, you cannot do anything against me. I only declare I intend to act. That's it. There is no mechanism to enforce it. National courts are not bound by an MOU. The other party cannot do anything if there is non-compliance with what was declared in an MOU. So it is a measure to avoid a legal binding. Nevertheless, those MOUs are a big problem, because if you're not following what at least a state declared to do in an MOU, you have a lot of problems which are connected to the term of macroeconomic conditionality. If you do not comply, no financial assistance in particular. I was just asking Philippe whether he could update me on another point where this macroeconomic conditionality entered union law. It was on the cohesion funds. I recall that there was a discussion that also the cohesion funds were now made up to macroeconomic conditionality. So then also those payments out of cohesion funds would be made conditional upon what was agreed in the MOU. So we see the enforcement is not legal. The enforcement is factual. It is an economic pressure, because a national parliament that has then afterwards to enact all the laws that its government declared to implement, if they don't do so, then there will be no financial assistance. So there is an alternative for a national parliament to say no and not to adopt a law. But this alternative means no more financial assistance, and that means state insolvency. And this means even tougher conditions for your people. That's why we cannot really speak of an alternative, but the binding mechanism is not legal. It's factual, it's economic. And this is now the challenge for legal academia. How to handle this? European Court of Justice and the majority of legal academia sticks to the old perception of things. Memorandum of Understanding is a different tool than international treaty. The difference is that there is no legal binding effect. Therefore, we cannot take it as an act which can be judged by a court. There is a minority opinion who sees this differently. This minority opinion has even a court decision of the International Court of Justice they can rely on. It's a court decision, Qatar versus Bahrain, in which the International Court of Justice said an old private law principle that it doesn't matter which form an act takes, you have to look at the effects. And falsa demonstratio non nocet is the Latin word for it. And then you look at the content, and if you see in the content, this is, even though formally it is not meant to produce legal effects, but in substance it is intended to produce legal effects, it has to be considered as a legal instrument, and by that as a legal act. That was the construction that the Portuguese Constitutional Court used in order to assess the MOU with Portugal when it declared some of the laws implementing the Portuguese MEU as unconstitutional. Nevertheless, the majority of legal opinions and the European Court of Justice do not see a binding legal force in an MOU. So if we have this as a starting point, we shall then now assess at which points human rights could be of importance in the European legal order, and what are the procedures to enforce them. Now, of course, the main instrument for the European Union is the European Charter of Fundamental Rights. The European Charter of Fundamental Rights has primary law, is based on primary law levels, so it has the same value as the other treaties. But there is a problematic article, which is the Article 51 of the Charter, which defines the scope of the Charter. And the Article 51 differentiates between union institutions and member states. And member states are only bound by the Charter when implementing union law. Now, when Greece is implementing an MOU, the question arises whether European fundamental rights have to be assessed when implementing an MOU. This only is the case if MOU is a union law, and here the European Court of Justice already decided a memorandum of understanding is no union law. By that, a member state that is implementing an MOU is not within the scope of application of the Charter of Fundamental Rights. Now, I will clean up my part once I'm finished. Now the other part, the union institutions. Union institutions are entirely bound by the Charter of Fundamental Rights. This was even explicitly confirmed by the European Court of Justice in its Pringle decision on the legality of the ESM by stating union institutions are entirely bound by the Fundamental Charter. Union institutions cannot act against the Charter of Fundamental Rights. All those fundamental rights contain a so-called obligation positive. That means they have to protect the interest of the individual, which are enshrined, which are protected then by the fundamental rights in the Charter. So the European Commission, European Central Bank, Council, European Parliament, all those union institutions, they have to protect those rights. Therefore, when the Commission and the European Central Bank are negotiating the MOUs, they cannot escape from their obligations of the Charter of Fundamental Rights by simply referring to the fact that we were entrusted by the ESM, which is not the European Union, so we are not bound by it. This is not a valid legal argumentation. Now, as I've already said, in the German system, the strength of the human rights is not coming from the fact that there are human rights. It is not coming from the fact that German institutions are bound by human rights. It is coming from the fact that there is a German constitutional court who is enforcing them. Therefore, the important point are now the procedures, which are the means to enforce those human rights against union institutions in particular, if they are not respecting it. And I'm not questioning the fact whether there was a non-respect, because the report clearly shows that there are a lot of human rights issues. So I'm now basing my assessment on the basis that there are human rights violations and that the Commission should not have negotiated such an MOU with Greece. Now, there are two possibilities, basically, to enforce the human rights according to the European procedural law. The one is that you ask for a review of legality under the Article 263, paragraph 1 of the TFEU, so legality of acts. And now we have a repetition of arguments. There can only be a review of a Union Act if there is a Union Act. An MOU is, according to the European Court of Justice, no legal act. Let's say for a moment we adhere to the position of the International Court of Justice in Qatar versus Bahrain, that doesn't matter which form it takes, it has a legal effect, so it could be considered a legal act. Now, the second condition is it has to be a legal act of a union institution. The MOU is formally concluded by the ESM. It is signed by the European Commission, but only on behalf of the ESM. So the European Commission is not the institution which is which made the MOU. It is the ESM. The ESM is no union institution under 263, and therefore a review of legality would be rendered inadmissible, as the General Court decided last November in case T327 out of 2013 on the Cypriot MOU. This decision is currently under review at the European Court of Justice. In March 2015, they launched a review procedure, but I have my doubts whether this will be successful. Nevertheless, it is a procedure to have a clear look at it. In this very procedure, of course, I think that the claimants made a mistake because they were not attacking the MOU, but the Eurogroup decision accepting the MOU. And this is then even more difficult because this is a political declaration. But now, if the MOU is not possible, what is with those negotiation parts of the MOU? Here, the European Court of Justice says the definition of an act is you need to have an action of a union institution which is intended to produce legal effects vis-à-vis third parties. Since the MOU is accepted after the negotiation by the ESM Board of Governors, the negotiations are preparatory acts for this final MOU, which do not intend to produce any legal effects, because the ESM Board of Governors has in the end to accept it. Those preparatory acts, according to the case law, do not fall within the scope of application of the legality review. Therefore, the procedure under 263 is just not admissible, even though on substance we have a human rights violation by the Commission. The second procedure that we can go for is the preliminary reference procedure. This means that the National Court refers a question of legality to the European Court of Justice and asks for interpretation or for a statement on validity. Advocate General Kokot, in her statement in the Pringle case, clearly said we have no problem of legal protection with regard to the ESM because, I cite, the compatibility with EU law of acts of member states within the ESM are subject under the ordinary procedures under Article 267 TFEU to review by the court, so the preliminary reference procedure. Besides this statement, she did not explain to which extent this is the case. Because what is the question that the national court would then ask the European Court of Justice? We have a national law which is cutting pensions. Is this in compliance with union law? And the European Court of Justice will say, well, which union law do you mean? Well, fundamental rights. Okay, but fundamental rights require that there is, because you are asking a question of a member state, that you implement, member state implements union law. Where is the union law that is implemented by cutting pensions? The MOU. I'm sorry, MOU is first, no legal act. Second, it's not a union institution act. So we have to render this preliminary question inadmissible. Therefore, also this path to go for a preliminary reference procedure will unfortunately also fail. So we have the situation that we have a human rights violation at European level, but no procedures to enforce them against union institutions. However, there is a trade-off, and this trade-off has to be seen. We do need those European institutions because European law takes precedence over national law. Which means if there is no union law, there is also no supremacy. Therefore, in contrary to union law, national constitutional courts, national courts are free to rule against MOU obligations because they have no supremacy. If they declare a national law as being invalid with regard to national human rights, the implementing law is then void in compliance with national constitutional rules, and European law cannot take precedence over this, because an MOU is no union legal act. There is no supremacy for such an MOU. But this brings us then back to the old problem. That's nice that national courts can do so, and we know, okay, there is no supremacy, but then afterwards Troika will come and says, well, you did not enact the law, even though it was your national constitutional court that did so we do not pay your financial assistance, and game over. This shows that we have to think about a way how to streamline the national court's decisions, which are free to decide on the legality of implementing acts based on MOUs, and those goals that are to be achieved on the MOU level. Because we come then to this ridiculous situation that there could be a human rights violation policy goal at the ESM level, which is rendered void by a national constitutional court, but still there's the de facto pressure on the member state to enact nevertheless, because they are dependent on the financial assistance. So this must have, therefore, an impact on the interpretation of an MOU. That's the reason why, from a legal academic perspective, I'm very much in favor that the European Court of Justice leaves the traditional perspective on an MOU as a non-legally binding act. There is an intention of a binding effect, which is based on economic necessities, but it has the same kind of effect as if it were a legally binding act. Only if we say an MOU is such a legally binding act, we can open the way to a preliminary reference procedure, and then to the European Court of Justice to state on the human rights issue with regard to this element. This requires a change of interpretation in European Union law, which is, unfortunately, I have to say so, currently not the case. And this shows that we have there a big lacuna, a big lack that can only be solved if either the European Court of Justice modifies its interpretation, or the primary legislator, so the member states, or let's refer to this famous 5 presidents report, are aware of the fact that we need to have a human rights court at European level in order to make politicians to anticipate the effects if minority rights are violated by those institutions. This is currently lacking. Even though everybody was saying we are a union of fundamental rights, we have this blind spot that no individual rights based on fundamental rights can be enforced in the European legal order. And that's my urge then to the politicians. Please think about closing the gap. The German constitutional reality and politics shows that if there is a threat of such a mechanism, this already has an impact on how politicians design the politics. Thanks.